We've been told by lawyers for years on the other side that if the government says sex means a piece of paper, then sex means a piece of paper. Well, the judges said they were wrong and we were right.
Hello and welcome to Spectator TV. Today, the Supreme Court has issued a judgment in the case between For Women Scotland and Scottish ministers, saying that the terms woman and sex in the Equality Act refer to biological sex.
The unanimous decision of this court is that the terms woman and sex in the Equality Act 2010 refer to a biological woman and biological sex.
We are lesbians and we rule.
What does this mean for women's rights groups that have been campaigning on this issue, and what does it mean for women's rights going forward? I'm Lucy Dunn, and today I'm joined by Michael Foran, a lawyer and lecturer at the University of Glasgow, and Helen Joyce, an author and a women's rights campaigner. Could you tell us a bit about what that judgment is and what it means?
So the case was predominantly about the question of what sex means in our anti-discrimination law. And the challenge that was being brought by For Women Scotland was arguing that sex is a biological term, and therefore all references to sex in anti-discrimination law, including references to lesbians or pregnant mothers, relate to biological categories rather than legal or certificated categories. And the judgment today has upheld that ruling, or upheld that argument, resoundingly. The Supreme Court has completely vindicated the arguments of both For Women Scotland and several interveners, Sex Matters being one, and then also the lesbian interveners as well. So this seems to me to be a pretty resounding win for those organisations.
And Helen, you've written a lot about women's rights before. How did this make you feel when you heard the judgment today?
I mean, vindicated, but also just amazed because, I work for Sex Matters and we were one of the interveners. We were very, very proud to be called on to make oral submissions in support of For Women Scotland, who are our friends and who we've worked with for years on these topics. And we've watched them fight their own government through successive courts. And, to be, first of all, to be able to talk to the Supreme Court, to put our submissions and then to see our arguments repeated in the judgment, we are on the other side from the Scottish government. Implicitly, the UK government argued against the position that we took. Amnesty International intervened on the other side. The Equality and Human Rights Commission, which is the regulator for equalities law, they intervened on the other side. All those well-paid people, all those lawyers, all those people who have lost sight of reality and who thought that the words are more important than the reality, that the possession of a piece of paper is what makes people man or woman, male or female, not the actual immutable physical reality of being mammals, they were all wrong, it turns out. Women who said it's a real thing to be a woman, and when you're discriminated against because you're a woman, it's because you're physically, biologically a woman, it's not because of your piece of paper. We've been told by lawyers for years on the other side that if the government says sex means a piece of paper, then sex means a piece of paper. Well, the judges said they were wrong and we were right.
And as you say, it's been quite a long-standing battle in many ways for women's rights campaigners. I think it was last November that For Women Scotland didn't have quite the same outcome with the Scottish courts. Can you talk us through a little bit more just how we've got to where we are just now?
I mean, the Gender Recognition Act 2004 was the first time that the government started to allow people to change the sex on their birth certs. And in case anyone's confused about this, you actually can't change your sex. It's not possible. We're mammals. It can't be done. So that was called a legal fiction. And then in 2010, the Equality Act was passed, and it wrapped up a whole load of other anti-discrimination laws, the Sex Discrimination Act 1975, the Race Discrimination Act, discrimination against disabled people, etc. And careless drafting between the two of them made all the lawyers who think that paper is more important than material reality think that the categories of man and woman, male and female in that Equality Act referred to the pieces of paper. So women who noticed that at the time have been arguing about this for a long time, but For Women Scotland have been arguing for years. Their own government is absolutely all in on the idea that you can change the piece of paper and that changes reality. And they actually passed a Gender Recognition Reform Act that was stayed by the Westminster government. But they've been taking cases on this for years, successively in Scotland, and then they arrive at the Supreme Court. And the judgment went against them in Scotland. But now the the best legal minds in the country have agreed with us. Isn't that nice?
And Michael, on that legal note, I suppose you've mentioned the Equality Act and also the Gender Reform Bill that passed through Scottish Parliament. Can you tell us a little bit what this means, this judgment today, about the law, both the Equality Act and the Gender Bill?
So, I mean, I suppose the first thing to say about that is that there's no legal effect on the Gender Recognition Reform Bill from this judgment alone. So it is open to the Scottish Government to reintroduce that bill into the Scottish Parliament, and then if the Scottish Parliament chooses to vote in favour of that bill again, there would then be a question as to whether or not the UK Government would like to issue another Section 35 order to prevent that bill from getting royal assent. My view is if all of those political contingencies occur, this ruling means that the dominant argument in favour of why the Gender Recognition Reform Bill could be blocked by the UK Government, i.e. the fact that self-ID legislation, a change to the Gender Recognition Act, would modify adversely the operation of our anti-discrimination law, well, the reasons for that kind of fall away now, because the Supreme Court has said that the Gender Recognition Act is a piece of legislation that enshrines an entitlement to get a change to your birth certificate, but it doesn't affect the operation of anti-discrimination law, single-sex spaces, sport, things like that. And a lot of the adverse effects that had been put forward by the UK Government to justify blocking the bill were because of the interaction between the Gender Recognition Act and the Equality Act. So if all of those political contingencies were to occur, and I'm not sure they necessarily would, there would be a harder legal argument for the UK Government to rely on to block a Gender Recognition Reform Bill again, because the bill would effectively simply be legislation relating to certificates that people can have privately, but which don't affect the way they interact with the world or how they interact with our protections in law for single-sex spaces or sport or things like that.
And I suppose thinking more about what this actually means in sort of real life, we've seen the Sandy Peggy case in Scotland really take hold in the last couple of months against NHS Fife, in which a Scottish nurse has spoken to her employers about how she felt discriminated against after she raised concerns about sharing a changing room with a trans woman. You know, how does the judgment today affect cases like that going forwards?
So those cases we would have argued, and we did argue in support of Sandy Peggy, the law was always being misinterpreted anyway. The law is overly complex the way that it was written. So the main thing that's happened today is that it's really simplified it. It used to be possible to keep out trans women who didn't have certificates saying they were women because they're just men legally. It was also possible to keep out trans women who did have certificates via another different legal route, but you got to the same end point. But nobody understood the law properly. It was complex. The EHRC did not give clear guidance on it. And organisations like Stonewall had really consistently misrepresented the law. So people like NHS Fife seriously thought that they were doing the right thing, telling a woman that objecting to having a man changing her sharing room. And to be clear now, the doctor in question is a man legally as well as physically. He doesn't have a gender recognition certificate. So it doesn't affect it directly. What it does is it just clarifies the law so much that now we can go back to people who said that self-ID was the law, which it never was, and say to them, look, you've really got this wrong. The one group which it would have affected the law for, the big group that it would have affected the law for, is lesbians. Because the way that the law worked, that this thing that I said that there were two different routes to keep men out of women-only spaces, that doesn't hold for associations. It held for single-sex spaces, it held for sports. It didn't hold for associations. So if the judgment had gone the wrong way today, an association of lesbians would have had to admit a heterosexual man who had a piece of paper saying he was a woman. I mean, that was actually a big part of why the Supreme Court ruled the way they did, because that's obviously not just outrageous, it's a destruction of the human rights of lesbians, because they, like everybody else, have freedom of association.
And I suppose looking at the politics side of things as well, I mean, you work in Scotland, Michael, and I suppose it'd be interesting to hear your thoughts on whether you think, I suppose, leading up to the 2026 Hollywood elections, whether the Scottish Government will try and have another look at the legislation that they had tried to push through under Nicola Sturgeon, whether that be in their interests, and kind of what the atmosphere maybe is north of the border about the sort of priority that gender identity has now on the list of people's priorities when they do look towards who they want to vote in next time?
I mean, I think that's a great question. It's slightly outside of my area of expertise, so I'm kind of just giving you some generic thoughts here. But my understanding is that, up until the Gender Recognition Reform Bill, there was basically one political question in Scotland, which was independence. Which side did you fall one way or the other on independence? And thanks to grassroots feminist organisations like Forum in Scotland, the political dial in Scotland shifted in the run-up to and in the aftermath of the Gender Recognition Reform Bill coming through the Scottish Parliament. And at that point then you had two political questions that were relevant, and one of them relating to sex and gender identity was not popular. At least the position that was coming from the Scottish government was not popular. The way in which this could go forward, I think, is kind of split in two lines. The Scottish government and the politicians in Scotland might look at this and say, this is a really contentious topic that we were on the wrong side of, so we should drop it and pretend it never happened and hope everybody else pretends it never happened. Or they could say, this is an issue of Scottish nationalism and the kind of sovereignty of the Scottish Parliament, and this was legislation that was passed by the Scottish Parliament that was blocked by the UK government as a result of our constitutional settlement that many people in the Scottish Parliament disagree with, and they might see this as an opportunity to revive the politics around the Scottish Parliament. My own view is that that's a pretty difficult political decision that will have to be made, because it's not as if the Scottish Parliament had been blocked from enacting legislation that was wildly popular in Scotland. And I think that then, generates the kind of tension that you might have between the two major political questions in Scotland right now.
One thing they will be looking at is they've just been really roundly defeated. Is it really what you want to do, to pick a fight with people who have just won so comprehensively? Because if they do this, women will just keep fighting. It's too important. It's existential for women that we can have the protections we need in law.
And I suppose that sort of comes back to what Michael was saying about the shift of a political dial. And I suppose maybe now looking at what political party leaders are saying on this subject, it does feel as though there has been movement, even in the last 12 months, about just where party leaders like Keir Starmer of Labour and John Swinney even himself want to stand on the issue. And to my mind, it seems it's only the Scottish Greens really that are left really campaigning, against what women's rights campaigners are saying. Is that something that you've picked up in terms of just how that has been shifting?
Oh, completely, it's been shifting. But what you've seen is a lot of people arriving at a totally untenable point, like the Keir Starmer line of 99.9% of women don't have penises. Keir, it's 100%. It's just ridiculous. Like when a sentence like that comes out of your mouth, you've got it wrong. And now the Supreme Court justices have said they got it wrong. So, somebody like Keir Starmer, who's a very clever lawyer, he obviously was ignoring the sort of common sense view, the view that women said, look, really no men. You might listen to the Supreme Court justices, and I think he'd be quite grateful, because that was a stupid line, and it was a very unpopular line. And, if you're willing to say that any women have penises, in literally every interview, someone is going to say, how many is it now? Are we down to 1 in 1,000? Wouldn't you love to have an excuse to give up this nonsense? So one thing the Supreme Court has done today is it's given all the politicians who thought this is a very complex issue, there's faults on both sides, we need to take the heat out of it, all those things, it's given them an excuse to just say the Supreme Court has spoken.
And Michael, just going forward, do you think, we've talked about clarifying the Equality Act and just getting that bit more sort of understanding of what exactly the law means. Is there more that can be done on this, or are we kind of at a really good point just now?
I mean, it looks to me, I'll caveat that I've not had an opportunity to read the full judgment yet. I've just, I was in the court, I was able to see the decision being handed down, and I've seen the summary. But this strikes me as, a piercing light of clarity through a lot of heat that has been coming and that has been thrown around in the political discourse around this topic. I mean, 2 points that I would say that I think are important to mention about this judgment. The first is that the conclusion the court came to was as a result of a very complicated legal argument about statutory interpretation. The justices did not take a straight down the line political assessment of what they think would be a good thing for politics, and they were clear when they were handing this down that this was complex statutory interpretation. And as a result of that, I mean, they very much affirmed the arguments that have been put forward by Forum in Scotland. Sex Matters got a particular shout out by the the court in the judgment that they had handed down, and the lesbian interveners as well. So the arguments that were put forward, the very complicated legal arguments that were put forward by these parties, were taken up by the court. And the second thing is that the court was quite clear that this judgment is not an attack on trans people. This judgment is a defence of the rights of women. It is a defence of the importance of biological sex as a vector for both oppression and discrimination, and therefore something that's worthy of protection in our anti-discrimination law. But the court was clear this does not take away from the anti-discrimination rights that transgender people have. They are protected, but they are protected separately in our Equality Act, in the same way that religion is protected separately from race. This is how our equality law operates, and nothing in this judgment, at least from the summary, would indicate that the court has come down in a way that has taken any rights away from trans people. This has clarified the law as it stands in this area, and it's brought, hopefully, clarity going forward into how the law can be applied in everyday situations like the provision of single-sex services or changing rooms or toilets. The law is now clear that when it says single-sex, it means biological sex, not certificated sex, not self-identified sex, but biological sex.
And Helen, on your side of things, do you think there's more that For Women Scotland and campaign groups like that want to do now to kind of push this argument, or do you think that this does mark a real turning point?
It's a turning point. It makes it very clear what equality law is meant to be doing and what, as Michael said, single sex means. But people have been misinterpreting this for so long that we now need to get the message out. And it's not us that should be doing that. It's the government, it's the regulators, it's the Equality and Human Rights Commission. But because this judgment is so clear, and because it makes the Equality Act operate clearly as opposed to via weird exceptions and, different routes for people who do and don't have pieces of paper, it'll just be the sort of thing that you can write on one side of a postcard. Nobody should need to get a gender studies degree. Nobody should need to have to read the Equality Act. You don't have to be a barrister if you're a pub owner and you just want to be able to have men's and women's toilets, because you know that if you let men into the women's toilets in a pub, bad things are going to happen. Now you can just, without any fear of legal action, you can say, that's for men, that's for women. I understand that you're a man who wishes that you were a woman, identifies as a woman, wants to be talked about as a woman, but you're not a woman, so you can't go into the women's space. It's made it very, very easy to just do that. But this is not the only law. There are other laws that have got screwed up by this idea that sex is a self-identified or a certificated thing rather than a biological reality. We have put in application at Sex Matters for judicial review of 2 other laws in which this happens. I'll just explain one of them, which is the Searching Act, the way that police search people. Police forces up and down this country say that if a male police officer has a piece of paper saying that he's a woman, he is entitled to strip search women. And I mean, if anyone has been strip searched, this is not a dignified experience. The law actually says that you must be searched by someone of the same sex, but they have been interpreting it as saying that if a man has a piece of paper saying he's a woman. It's a different law, so today's judgment doesn't mean that that falls away automatically. But it would be a very brave person who reads that judgment and thinks, these arguments work for lesbian associations, these arguments work for single-sex toilets, these arguments work for, changing rooms. But you know what? We'll let the men strip search the women because that's a different law. So we are going to have to do the work to push the judgment through all of those other laws and to make sure that people understand it and to make sure that the government and regulators speak up. But listen, this is 10 out of 10 no notes.
And Michael, just to wrap up there, I suppose we talked about the government having to do a little bit more now. We've got this clarification. And I suppose looking at the Sandy Peggy case, we did see a bit of institutional creep in a sense of the NHS Fife maybe going slightly ahead of where the law and the government were actually at on paper. Do you think that there's more that institutions themselves can do to try and enact what we've seen today as legislation?
Oh, absolutely. I mean, I think it's been said earlier on that policies based on self-identification have never been the law of the land, and so this judgment doesn't alter that in the sense of the legal reality of any organisation that was running a self-identification policy. They were always operating in breach of legal obligations. What this judgment does is it clarifies very clearly, in a crystal clear manner, exactly where the law is on this area. And so, yeah, I mean, there's going to be an awful lot of organisations that have been waiting for this judgment to see which way they're going to jump, not really realising, I think, that they were already in legally shaky waters to begin with. But now what's happened is people who are in those organisations can point to a Supreme Court judgment to say we need to update our policies to make sure they accurately reflect the law. So work has to be done on that front. Work already had to be done before we had got to this judgment. But this judgment, I think, will be a catalyst in a lot of areas for people to really take the equality law that we have and implement it properly.
Well, thank you, Michael, and thank you, Helen, and thank you for watching.